Yes.
Okay, all about the TV timeouts. Like she said, my name is Josh Andrews, and I work with entrepreneurs and small businesses every day. I'm the managing partner of Gatehouse Law. We're a boutique law firm that focuses on providing comprehensive legal representation to business owners that's accessible, predictable, and approachable. Our mission is to lower the barrier of entry to legal by offering an education-first approach to legal services and advice, and that's why we're here today. Now, like I said, I'm a business lawyer, and I know business law. I don't practice business law in between divorces and speeding tickets. My practice is focused on small businesses and startups. In fact, we have resources. We're going to talk a little bit about that. I have a blog and a podcast, and we've got an ebook that we're going to give away to you guys to help you understand the legal that impacts your business. The ebook today is going to be focused on your trademarks, which makes me especially geared to talk to you today about your business. Now, the thing about being a lawyer is when you come to a lunch and learn, unless you offer free food, everybody just expects to be bored out of their mind listening to you talk and hoping that they get something at the end. But my focus is on getting you information today to help you understand the trademarks in your business, to understand how they impact your business, and how they can help your business grow. So that's going to be our focus as we go through. Now, like Kim said, I was telling her earlier, I'm really excited about this. Trademarks is one of my favorite talks. I think it's really exciting. It's really interesting. It was one of those classes in law school that I completely nerded out over. I enjoy doing trademark stuff. I enjoy talking about what it is. I just think it's cool. Trademarks mean something, right? They're how you recognize a business. And when you've got a trademark that becomes something, you're able to say things like the golden arches, right? And that conjures immediately an image of a business. Good or bad, it conjures the image of a business, right? We all know what the swoosh is. If we say just do it, we know who we're talking about, right? And as small business owners, we all want that. And so the question is, how do we create that and get it to be the just do it of your industry, right? So that we understand what it is. It's so out there. It doesn't mean anything until it's associated with your brain and it becomes that. And so my goal here is to help you understand what a trademark is, to understand how to actually protect your trademark even if you haven't registered it, and to help you enforce your trademark when you find that someone may be infringing, and to understand what infringement of a trademark actually is. So we got to start with what in the world is a trademark, right? Everybody hears about it, everybody thinks that they understand it, everybody, sees stuff floating around. You kind of generally know what trademarks are, but what is it legally, right? Actually, what is it actually in the law, and what is it that we're protecting? Well, it's a word, phrase, or graphic symbol, right? That's like your icon, and we'll talk about that in a little bit. Used to show the source of goods or products or services, and we're going to talk about the difference between a service mark and a trademark, which are technically the same thing, though they're kind of classed a little bit different. But it's to show us who it is. So like what I was saying, just do it, right? When we hear that, we know if just do it is on something, it means that it came from who? Nike. Oh, Reebok. So we know that it came from Nike because it means something, right? Because it shows us where it came from. And so that's what we're kind of looking for. A service mark is a word, phrase, or graphic symbol used to show the source of services, right? Things like law firms' logos, grounds maintenance companies, those are service marks, right? If you offer a service, if you are paid for the thing that you do, not the thing that you have created, then you offer a service, and we have to make sure that we understand that. Now, sometimes in our modern culture, we have a slight blend of services and trademarks, right? And so a good example is actually UPS and FedEx, now that they've bought, I can't say now that they've bought Kinko's, I guess that happened a while ago. But, UPS as the UPS store, and they have the trucks. And so UPS offers products and they offer services. And so depending on what you look at, you'll see an SM or a TM, or in most cases with UPS, it's the registered R, which we'll also talk about the symbols. My goal is just so you know what the symbols mean by the end of today. So we do have to kind of pay attention to what those are. We're dealing with, say, software as a service companies, right? What is that? Is it a product? Is it a service? We've got to figure out what that is to make sure we know what we're protecting. And it's about understanding what it is that you do, right? You can do a lot of things, right? Nike's in shoes and sunglasses and hats, and they're in everything, right? So they're all over the map, and they're protecting themselves in various places. And so we have to understand what it is you do. And as a small business owner, you may start small and grow. and you can only protect what you are doing as you're doing it. And so we're going to talk a little bit about making sure we understand that. So I do want to, before we get started, because I hear this a lot, the distinction trademarks, copyrights, everybody always gets confused. It's intellectual property, right? What is it? So it's kind of like a square and a rectangle. So a trademark always has a copyright, but a copyright isn't necessarily a trademark. So if you're looking at an icon, right, like this, is a trademark of ours. Now the artist who designed this for us has a copyright in it, right? Because they actually created this. It's artwork that they did. It's copyrightable. But it's also a trademark, right? But if you write a book, you obviously have a copyright in your book, but you can't trademark your book, right? So it's kind of understanding what that is. In the small business world, what we're looking for is to protect our words, phrases, business names, icons, and things like that to make sure that no one else can use our words and names and phrases to try to look like us, right? And we want to protect that, right? So if we put, say, the Golden Arches, if this was the Golden Arches as a law firm, McDonald's is sending me a cease and desist letter, right? Now they're not in, we'll talk a little bit about services, right? They don't do law, but the Golden Arches is so prolific that they're able to stop me from using it because they use it in so many different places. Copyright is the protection of an original artwork, and it protects the work of the creator, whereas trademark is protecting the business and using it in trade to say this is who we are, right? So like using the just do it as an example, right? Just do it doesn't necessarily have copyright protection. It's a simple phrase, right? It doesn't mean anything. It's used all the time. That's not necessarily Nike, and they can't shut everybody down. But if you use it to sell clothes, especially athletic clothes, they're going to send you something, right? They're going to tell you to stop, and that's where our distinction kind of comes in. So now, symbols, right? We see these all over the place. We see the TM, we see SM sometimes, and we see this R with a circle around it, right? These are your trademark symbols. They all mean something. They're used in specific times.
C?
Do what?
What about the C with the circle?
That's a copyright. So that's different. That's the copyright we were just talking about. And it is technically different. We can get to that if we have time on the question.
So you were saying trademark symbols.
Yeah, so these are the trademark symbols. So the TM and the SM, these are what's called common law symbols. You can use these because it's your trademark. You can use these because it's the name that you created for your company. You can use these next to your logo. You can use these, say, this is my trademark, right? And so we're going to talk about this is trademark, this is service mark, and we're going to kind of break those down in just a little bit to understand what they are. The TM indicates it's the source of goods and products, right? For the TM, that's if you're selling shoes, or you are selling chocolate, or you are selling something specific, a product that people are purchasing. That is the TM, right? That's a common law trademark for what you're doing. Typically in your online businesses, if people are consuming content, that is a trademark. You're not necessarily offering a service because you're creating content that is being consumed, which is actually a product, even if it's free. And so that's where we get that. Now you can use that the second that you put it in commerce. The second that you say, this is who we are, you can use that TM from a common law standpoint, and it puts people on notice that that is a trademark that you were using. The SM, like what I was saying, is for service mark. That is something if you were providing services specifically to someone. So if you were actually being paid to create services, to create a thing, and you were being paid for the work you do to get to the end product, then you're doing a service. So we as a law firm, we create contracts, right? We don't sell contracts, we sell the service that gets you to the contract, right? You pay us to make it for you, you don't pay for the product. And that's kind of one of the distinctions. That's what makes us a service company, as opposed to, say, Robert Shapiro's company that offers you things that you buy, right? That's a trademark. Because you just give them stuff and they spit it out of their auto-generated website, and so that's a trademark that you would particularly use. We actually have a podcast and a blog that we use, Legal to English, which is a trademark, right? Because we're offering a specific thing that's consumed. There's no service associated there. We're providing information, and we're providing giveaways and handouts and stuff like that. Those are those are products. Now, this R with a circle around it, don't use it until the United States Patent and Trademark Office says you can. The R with a circle around it is a federally registered trademark. You actually go through a registration process, you go back and forth, and you get a fancy piece of paper that's gotten less fancy over the last decade, but a fancy piece of paper nonetheless that says that you have a registered trademark and it's registered on the United States Patent and Trademark Office. Not in Alabama, which is another type of registration you can do, in the federal registry, and it comes with certain rights, but the only time you're able to use this is if you've actually gone through that process and gotten that letter back from them. Otherwise, please don't use it, or we'll be dealing with other kinds of problems, like fraud and stuff like that. So, and I like to talk to you to protect it, not when you've defrauded everybody. That's we're going to play a little game. So trademarks, right, are that's for products, the source of products. Service marks are the source of services, right? So we're going to play, is this a trademark or a service mark? And we'll start with this one. I've already given you the answer. Service mark. Okay. How about this? We'll go local. Trademark, right? And does everybody have it?
Yeah.
Oh, man. Okay, you should go find it. It's amazing. I'm sure they'll be at Pepper Place this weekend, so just go locate them. Okay, Forge, trademark or service mark? Kim?
Service. I don't know. We're a location, though.
You are a location. Yours is one of those that's kind of a mixed bag, right? So from a technical standpoint, because you get to use the space, you're a trademark, right? So when you're actually selling yourself as a co-working space, it's a trademark. But there are things that you do, if they become branded, that are service, right? Ancillary services that you provide. This is for my clerks.
Oh, goodness.
Service mark.
No?
That's a trademark.
Trademark. It's a game. Yeah. But anyway, okay, so yeah, we've got a trademark, a very successful one at that, at this point. So, okay, so now let's talk about actually making sure that your trademark works, right? We're all in the early stages of our business. We're in various stages. We're small businesses, and we need to make sure that we have a trademark that can be protected, right? And so there are some rules, obviously, some things that you actually have to go through to make sure it works. There's some things that we look for to make sure that you have a mark that can be protected. One thing it can't be is merely descriptive. It can't just be what it is, right? It can't just describe what you do, right? You can't have a phone book. That's why the Yellow Pages is called the Yellow Pages and not the Yellow Phone Book, right? Because it has to be something other than exactly what it is. So if it just immediately conveys knowledge of a quality, feature, function, or characteristic of the goods or services, it's merely a descriptive mark. There's an example that I use, and if you've been to Co-Starters, you've probably heard me talk about this. Down on 280, there's a bar that's called the Scotch and Cigar Bar. Right? I mean, it is what it is. I'm sure it's amazing and lots of fun to go to. I've never been there, but it's the Scotch and Cigar Bar. So if I decided to open one down there, right, and I open the Scotch and Cigar Bar and they send me a cease and desist letter, I will laugh at them because there's nothing they can do to protect themselves because all they've done is said, we're a Scotch and Cigar Bar. Well, sadly, about 9 months ago, I noticed on my drive home, they've changed it. Now they're the humidor room. So they may actually have some level of protection, probably because they finally sat down with a lawyer who told them there's no benefit here to you. And they spent a lot of money on a big sign. But so the key is the merely descriptive part. Now we can have some level of description of what you do, right? And the modifiers are, can be important. So like for instance, our legal firm name is now Gatehouse Law, right? Now we don't own protection of the word law. It would be awesome if we could, but we don't actually own that because other law firms need to be able to use it, right? To describe what they are. We have protection in the name Gatehouse because it is something, right? It takes this mental leap to understand what we are, right? There's a story behind the name that we have. There's a story behind who we are and what we do. And that's what makes it different, right? It's not just a couple of partners' names on a door. It is actually a brand that exists, and that's what you're aiming for as well, right? Is to be something other than simply what you are, right? There's got to be something that's different. That takes that leap. So let's talk about how we create these distinctive marks that aren't merely descriptive, right? And there's 5 categories that we kind of go through. There's a fanciful mark, right? It's something, that's just a fancy way of saying, a particular thing, right? There is an arbitrary mark, right? Apple computers. What does that have to do with anything, right? It just is. It's a word. Gatehouse for a law firm. It's an arbitrary mark. It's not actually anything necessarily associated with what it is. Something that's suggestive of a thing, right? Google might actually be argued as suggestive because it's pulled from a Googleplex, which is the amount of results that they were hoping to be able to achieve, right? Is a Googleplex of results for your question. That's why they named themselves Google. So it's
spelled it wrong.
Right. It's suggestive because it's there's a brand that's associated with it, right? Descriptive. This is where we start to get into this. So descriptive can work, but if it's merely descriptive, if there's none of these other things, then we potentially lose it. Or generic. Generic is where it becomes dangerous, right? Aspirin, right? And we're going to talk a little bit about letting your mark become generic because you want to be known, but you can't let people use it to describe your product because all of a sudden it becomes what your product is, and you cease to have any protection. You can protect a mark that's fanciful, arbitrary, or suggestive. You can't protect a merely descriptive or a generic, right? So it has to have something else if it's going to have something like this. If it's going to be descriptive or it's going to be generic, then you're going to have to make sure that you have something else to make it have some level of protection, right? One of the other issues that we have, and this goes into the descriptive side, is if we're using, say, like the location where we are, right? Like if Kim had named Forge Birmingham co-working space, there's zero protection, right? Because it's a co-working space located in Birmingham. We have no protection. Instead, she chose something awesome that's connected with, that's connected with who we are, right? It's connected with who we are as Birmingham, and it draws a certain connotation, and it also brings together what she is doing here in forging together relationships as part of the entrepreneurial development in Birmingham, right? Is that accurate?
Yes.
I tried. Okay. And so the strength of a mark and the level of ability to protect it goes into how strong it is, right? Fanciful, arbitrary, and suggestive. Those are where we get strength, right? That's how when we send a cease and desist letter and we're arguing that someone's doing a certain thing, that we're able to argue that we've got strength in that particular mark, right? So what we want to do is we want to pay attention to what you do. We want to make sure that your mark, that what you're calling yourself, that it's suggestive of what you do and not descriptive of what you do, right? So things that can't necessarily be registered, right? Let's think about a National Registry of Medical Pathologists, right? That's horrible. It's actually been tried and failed. So that National Registry of Medical Pathologists, go talk to a branding company because it's not going to go anywhere, right? The National Chamber of Commerce, right? It is what it is, So descriptive and generic marks can be registered because they simply describe a product or service, and there's no way to truly protect it because there's no way to go and say, you can't use this mark because I'm using this mark, because it simply describes what it is, and you have to be able to describe what you are. That's why I can't own the term law in my law firm, because then I'd be sending cease and desist letters to every law firm in Birmingham, right? And so you've got to find something that is separate from that. So in which case we will need to talk about disclaimers here. So Easy Bake Oven, right? We've all heard of the Easy Bake Oven, right? It was actually ruled to be merely descriptive. Oddly enough, the Easy Bake Microwave Oven, I think, is what they originally actually called it. But they ended up actually being able to achieve registering Easy Bake, and they had to disclaim what's called oven because they can't own oven, right? Because there's other little things. So they were able to get the Easy Bake part, right? And so microwaves can't actually call themselves Easy Bake because the toy wins, right? And so they actually abandoned the mark and then revived the toy anyway. So that's you have to understand that if you're going to use a term that's actually associated with what you do, like law or something like that, then you're probably going to have to actually disclaim it. That doesn't mean you can't protect the whole mark itself. It just means that you're not going to claim ownership in that, which is why our legal name is Gatehouse Law, but our brand actually just says Gatehouse because we knew we would have to disclaim it anyway. And so it gave some level more trademark protection to actually remove that from our name. So now when we get into registration and protection of a mark, there's actually two different types of marks that we look at. Now, service mark and trademark are technically two categories of trademarks, but there are actually two separate types of trademarks that we use when we're actually registering and applying for protection of a mark and what it looks like. So standard character is words. It's the word gatehouse. It's the word forge. It's those particular words that are associated with what you do and what your business name is, right? To Ravens is a word, right? Special form is the look and feel of that. So everybody has seen, what's a good example? Google, for instance, right? Google is a protected trademark, the word itself, for search engines and whatever else in the world they protect. I haven't checked in a while. But so Google is a trademark. They've got Google, but they also have the look that you see, right? The drawings. The way that they have it, and I'm not sure whether they've done colors or not, but they actually have the look of that. So they both have the word and the look of it. And the reason for that is that means people can't use the word Google to try and convince people to use it, but they also can't use something that looks like that word Google, right? And so those two distinct ways of protecting things, they're important to understand. The standard character in the early stage startup of a company is often the safest bet and the safest way to go. And the reason is you know what your brand is, you know who you are, but your logo, the look and feel of what you have could change, right? Because, who knows, right? The iterations that you go through, and if you register the special form, it's every single time that you register it. And I'm sure you guys probably don't watch as much as I do, but you'll see when a big company undergoes a brand change, you'll see them go from the R with a circle around it to a TM, just because they've made slight alterations in the brand, right? And so there's a slight alteration, and the reason that they switch that is they're going back through the registration process. And so in the small business world, you want to make sure you get the protection that you need in the early stages, and then as you develop a brand that you know has protection that's gained traction, then we start talking about your special form. Now, in some cases, there are times that you want to play with your icon, right? You know that it's there. You want to make sure that you've protected what that looks and feels like, right? You want to make sure that you have that level of protection because it has a certain look and feel, and you're afraid of people coming back. So at the very end of this, we're going to break down trademarks and what all you can register separately. But these are the two kind of primary things that we look at when we're talking about actually registering and protecting a trademark. And it's the decision tree that we start with to determine how to protect your business. And so, like, if you were to come to us to talk about your trademark, we're going to take everything that you're using in trade and we're going to break it down to determine what makes the most sense in your mark and what makes sense to protect it, that we should use now, and then how we should time it moving forward. So, we all want to know how to protect them, right? So we've worked really hard, we've done our research, we've figured out how to protect we've figured out a good name that we think has some level of protection. It's awesome, we're really excited about it, we want to move forward. How do you protect it, right? Like, what do you do? So there's two different stages, right? One is before you launch. So the big issue with trademarks is you can only protect a trademark that's actually used in commerce. Right? So in the law, trademarks tell us where the source of goods or services are, which means that those goods or services have to be being offered in some way, shape, or form, right? Otherwise, we can't necessarily protect it. So how do we actually deal with it? So number one is an NDA, right? If you're talking about something, if you're thinking about something, you're talking to a branding company, you're talking to potential investors, you don't have all of this stuff, you have this name, but it's not necessarily in commerce, that's when we put people under NDAs. I have my opinions about NDAs, I've written about them, I think they're overused in the small business, entrepreneurial world, but sometimes they actually do have a benefit. And if you are in the early stages before launch and can't figure some other way to use your mark to get it in commerce, then we need to put those people under an NDA so they don't steal it and move ahead of you. Especially if you're talking to people who have money to invest in your company so they don't take their money and go do it somewhere else, right? We want to make sure we put them down under something else. Number two is registration. You can actually pre-register a mark. It's extra expensive. We don't often recommend it, but sometimes you do need to do it. And that's, you file what's called an intent to use mark. You file a mark that says, I plan to use this trademark in this way. right? And so then what happens is 6 months later, you have to actually show that you've used it or file another extension application. You can file it up to twice. So you can get up to 18 months of it. It costs a lot of money. Because you keep having to file these extensions and pay your filing fees. So you only need to do this if you can't do the third one, which is do something with your mark, right? If you have an idea, if you want to do something, create a web page, put it on there, start collecting email addresses, tell people you're going to tell them what's going on. Because you know what? Email addresses are currency nowadays. They're worth something, right? They mean something. They mean that you have the ability to communicate with them. There is value associated with that particular list, right? I mean, there were just hearings on the Hill about using people's information, right? It means something now. So you want to actually make sure that you've gone through and protected before launch, and the number one thing that we always recommend is action. If there's some way that we can put it together, then we want to make sure that we can do some level of action. So then the next question always is, in the small business world, do I have to register my mark right now to make sure I have protection? No, you don't. And anybody who tells you that you absolutely have to is just trying to take your money. Now, sometimes it's beneficial. Number one, though, use those common law marks, right? It's about notice. It's about letting people know what's going on, right? Now, the big issue is absent a registration of a trademark, you are limited in protecting your particular mark in the place where you have offered your products or services. So if you're located specifically here in Alabama and you've only ever operated in Birmingham and you have plans to move to Tennessee, if somebody gets there before you do, then you don't have any protection absent the registration. And so sometimes the registration of the mark does make sense for the sake of knowing that you're going to expand, but you're actually trying to start small and grow. So how do you solve that problem in some places? Number one is we often recommend your business name registration. In Alabama, you can reserve a name that for your business that's anything, right? Your legal business name doesn't necessarily have to do with what you do. So Forge, for instance, Kim could have started a company that was called Kim's Awesome Co-working Space, right? Because she didn't actually know what it was going to be. And then she could have done business as Forge, right? And then she's got protection here because she's doing her work here and she's offering that protection. Now, instead, if she actually goes in, and I haven't actually checked on Kim, so I'm assuming, if she names it Forge as the name of her company, right, then she's got this business name registration that's registered in the state of Alabama, and she's de facto protected herself throughout the state of Alabama because nobody else can use it.
Who do you register with?
With the Secretary of State. Like, so when you file, when you form a company, you register with the Secretary of State the name, and then you file with the probate court in the county where you're going to be located. Yes.
So, like, say, for instance, our registered name was Forge Workspace.
Okay.
But we do business as Forge and go outside of Alabama. Can you still do business as Forge?
You can still do business as Forge, yes.
Okay.
So you've got this. So this is about kind of it's an underhanded way of getting some level of trademark protection. Okay. That's really what we're talking about. But in your particular case, you're using less than the full legal name. It's kind of like us trading as Gatehouse, even though our legal name is Gatehouse Law.
Yeah.
It's because when you see it, it says redefining business law, so it gives you some instance of who we are. Mm-hmm. Whereas if we're just talking to people, we need to be able to say Gatehouse Law, because otherwise how do you know what we are? Because we have a suggestive, fanciful mark, right? Mm-hmm. And so you do have that level of protection. And the point is that we have information, we have some level of protection that says the Forge is a business that's used in the state of Alabama. Now, from a technical standpoint, somebody can actually come in and form Forge LLC or Forge Inc. and come in under your radar and form it because they're only checking to make sure it matches exactly, right? Now, do you still have rights to stop them? Yes, you do. And that's because you're using this mark and you're using it throughout, and you've done the things that you're supposed to. You know, you're on Facebook and you're talking and you've actually got a space. And so if somebody comes in new, you go in and try to shut them down, right? And that's what we're talking about here, is making sure we preserve these level of rights. And that's where this notice comes in, right? This is using your mark, telling other people that it is your mark, right? So Forge is out there on the street, right? Forge is on Facebook, and it's in all of these other places. So and so we want to make sure that we provide that notice. And then if we do find out that somebody's doing something with our trademark, then we have to send these cease and desist letters, right? Now, I find in the small business world, if you find a new company is formed underneath you that's competing with your brand that infringes, that they probably didn't mean to. So, and this is a place in the small business world where we have to be really careful because the cease and desist letter is a scary, nasty letter, right, that we lawyers send. It says awful, awful things, and sometimes you have to temper it and say, I know you really like to do this. There's an example, Jack Daniels actually did this several years ago. There was a guy who used, he had a book and he had art designed for his book cover. It looked like the label from a bottle of Jack Daniels, and their lawyer sent a really nice cease and desist letter that said, hey, listen, here's the thing. We think it's awesome that you're a fan of ours, and we think it's awesome that you want to look like us, but if we don't stop you, we lose the benefit of our trademark, so we really need you to stop. Jack Daniels actually paid them to redesign their jacket cover. Because it was a legitimate accident. They had no idea. They didn't understand what was going on. It was copying someone is the sincerest form of flattery, right? Imitation, sincerest form of flattery. Then that was it. But from a legal standpoint, you have to protect your trademarks. And so, yeah.
So, for an example, local example, Aviate Fashion, right? They
Yes.
came out with BHM hats. When
Yes.
they realized they can't trademark the BHM airport logo. So
Right.
you have other companies like Code or whatever that come in.
Yeah.
They really can't do anything to stop that particular thing, even
Right.
though it was intentional, because you can't trademark that airport code.
Precisely, yeah. So you can't own that, right?
Right.
Whereas, an alternate example, Original Birmingham, who's got the BHAM hats, right, and the BHAM logo, that is protectable because it is something that's original, right? And so those are different because BHM, you can't take that ownership because it just is our airport code. It's where we are, and so you can't protect that. And that's where understanding these things, and I don't know if they do that, but that's one of those is first to market, right? Because
Right.
you want an Aviate hat, that's what you want, and so sometimes you are making that decision because Aviate is protected, and so then if someone were to come in trying to sell BHM hats under the Aviate logo, they're able to shut them down, but they can't necessarily stop the hats themselves.
Right.
Now infringement. Infringement is the bad stuff, right? And it's important to understand. It's important to understand to make sure you don't infringe and that you understand what's going on if you think someone is infringing. A lot of times we like to work with our clients to protect their brand, and a lot of times we're watching for infringement. Sometimes we're arguing on behalf of our clients that they're not infringing on particular trademarks and things that they're dealing with. But basically, trademark infringement is any act that interferes with the exclusive rights of a trademark owner, right? And so the issue that you're looking at is what are these exclusive rights? What interferes with it? What makes it? And that's where we get into what's called the likelihood of confusion. So the issue in trademarks are if you're using a trademark, if there's a likelihood that it's confused that you are the same company, right? So for instance, and we'll use McDonald's as an example, even though McDonald's is a restaurant chain, right? They're so big, if you use McDonald's auto repair shop with golden arches, it's become so big that there's actually a question as to whether or not McDonald's decided to get into the auto body repair for all of the people that run into their signs. So the question is there going to be a likelihood of confusion? So if someone were to start something that didn't offer the same products or services that you did, then there's not necessarily a likelihood of confusion, right? Like if there were Gatehouse shoes, right, then I'm not going to be able to send a cease and desist letter and say, hey, I'm a law firm and you need to stop because there's a likelihood of confusion that your shoe shop and my law firm are the same people, right? Right? That's not going to necessarily be the same thing. But the point is, and the protection that you're looking for is anyone that's trying to look like you, right? Trying to make it look like you're buying stuff from your company, even though it's not your company, because they're basically taking your money away, right? Because people think they're buying stuff from you. This happens a ton in the tech space, in apps and things like that, in the app store. You start to see, you get one an app that hits the top of the app store, and you see a bunch of other little apps that are named something very similar, or use the name of the app within the description of the app just so that they get pulled up. So when somebody hears, hey, this game is super awesome, right? And so you start to pull that up. So, those are the kinds of things you're looking for, is people who are trying to use your terms to get what people would otherwise be paying to you, right? So we want to make sure that that we're not using anything that's confusingly similar, and that's what other people are doing. Now, the other issue that you actually run into is common use. Is that it actually runs into where if you allow someone to use your brand so often, it actually ceases to have any protection because it's so common. Aspirin was one of them for the longest time. Aspirin is aspirin, right? It wasn't at one point, but that's what it's become. Cellophane is the same thing. Cellophane at one point was a trademark, but everybody used it so often that it became what it was. Like, people just understood that as the noun for what it was. Google is running a very fine line with it because it's become such a cultural thing to say, is that you Google something and they actually fight it. They push it. And that one's a really interesting one because we're in a new world, right? Aspirin and cellophane people were actually advertising using that. Those were the words that were used so often, but now we live in a very different world, right? Where people in movies say Google and people online say Google, and that's just kind of what we get, where it's become this verb. But they are working very hard to protect that, to make sure it works. Kleenex actually almost ran into that. So Kleenex, it was used so often for facial tissue, right? And they fought really, really hard. And now all of a sudden, nobody uses the word Kleenex anymore, right? It's facial tissue everywhere. Because usually people were actually using the word Kleenex because it becomes so regular. And so, you want to become prolific, right? You want to be associated with a thing, but you can't become the noun, because then you just become a generic thing, right?
Band-Aid.
Band-Aid. They worked really hard as well. Band-Aid, so they still maintain the protection, but they worked really hard to fight it and make sure that bandages is the noun, right? Not Band-Aid. But yeah, that's a very, very similar one. And of course in the South, like Coke is what, but that's a slightly different thing because that's just a colloquialism that we say, but they do have to be careful and make sure that they're protecting it. And that's the key with trademarks. With a copyright, if you write a book and don't protect it, and then one day decide that you don't like all these people who are copying your book, then you can protect your copyright because it is. Like, they copied it or they didn't. Your trademark, if you don't protect it, you'll lose it. And so you have to actually, that's a decision that you have to make, is to actually go after it and make sure that you're protecting it.
So that's like that Jack Daniels example?
Yes, they went after what arguably could have been one of their biggest fans, right? And so they had to be really careful, and that's a place where, I hated to their lawyers for making a good choice and not just sending a form letter out, and doing the right thing, and I imagine it probably wasn't the lawyer, it was probably one of the C-level executives. It was like, I want this to go out this way, and we're going to pay for it. That's probably what they did, to protect that, because they're also looking at protecting their brand. In that case, it was, we don't want to be a bully brand, but they legally have to protect it. So it's about educating their customer base, right? Because obviously the guy liked Jack Daniels, right? So you want to protect your mark until it's as distinct as the golden arches. I've used those regularly. We all know who I'm talking about, right? And it means something. It's big. You can't use golden arches for anything because they are the golden arches. And they've gained this level of distinction and they've protected themselves, and you want to make sure that that's what you do, and that's what we're aiming for. To make sure, I told you I was excited. I'm trying to get through this so I can answer questions. But your rights and trademark, these are the rights that you actually have. You can use your mark. You can license your mark, and we actually do that sometimes. If you've got a big company, that sometimes you have a company that owns your rights, and then other companies that use it, right? Restaurant chains, franchises, things like that, right? Like when you're using them in different places, you are potentially licensing that mark. You have the right to register the mark, to keep other people from using it, and even to transfer the rights to your mark, right? You can sell it. It's a thing that you own, which is important. And then here are, when we're protecting our marks, when we're looking to actually protect our trademark, when we think that someone is actually infringing, right? These cease and desist letters are actually a part of what we're sending and what we're looking to do. And so these 8 things are kind of how you build one of these templates, but like what we've talked about with Jack Daniels, sometimes it's softer than what these things sound like, right? But we've got to make sure we talk about your mark, where we show where the infringement happened, how long we've been using the mark, because that establishes that we've used it longer than they have, because that's important. Evidence that you're still using it, because you can't protect a mark that's dead, if you quit using it. The fact that you didn't give them permission is an important piece of it, right? If you have any examples of confusion, like if you've gotten phone calls for people thinking that these people were associated with you, you want to point that out. You want to actually ask them to stop. This is important. People will send letters and they forget to ask for something, and you want to give them a deadline, right? And the point behind this is that we want to make, whether it's nice or it's harsh or however we've decided to actually make it work in your business for whatever the purpose behind your cease and desist is, we want to make sure that this is contained, because these are the elements that you're going to have to prove if they don't stop. And you actually have to take that next step to go protect your mark. So this is what we're looking for to make sure that we can actually move forward to protect your mark. So before we stop, can anybody count? Let's name the actual protectable trademarks that exist within this. If you work for me, you don't get to do it.
The symbol of Gatehouse.
Okay, the symbol,
The word
Gatehouse,
The font and color.
the font and color. So we got both the word and the way that it looks, right?
Oh my goodness.
Okay.
The tagline.
The tagline, yeah, redefining business law,
And the whole thing all together.
and the whole thing all together. You almost
Is
have
that
gone to
four?
co-star.
Is that
Yes,
Is that
4. Yeah, we've got 4, and then we could technically do just this, right? You could do just this, right? You can break it up in however many ways you want to, and so that's one of the things. If you go to actually talk to a lawyer and you say, "I want to trademark my brand," and they don't say, "Let me see your brand," unless we're just talking about your name, right? There's a lot of things that we're looking at protecting, and the question is, how do you actually put it all together to make it work? And often what we actually do is we recommend that you protect the parts, because if you've protected the parts, then the whole itself is protected, right? And so if we protected, if I was representing myself, right, and we protected Gatehouse as a standard character, and we protected redefining business law as a standard character, and we protected the icon as a special form, and not claiming color, right? So we're gonna disclaim color, so it's basically a black and white icon that looks like this. The whole mark is protected, right? The whole thing. Now I can come in and I can protect this and the color scheme and all of those things that I want to, if I'm trying to create some kind of trade dress protection or something like that. But the reality is that blues and grays, that's a relatively popular service firm color scheme, right? And so when you're looking at actually what you're trying to protect, those are the kind of things that you're breaking down, and how do you get the biggest bang for your buck in protecting your trademark? And so that's what you're kind of looking for. Trademarks are your mark in the world, right? They're your mark on the business community. They are who you are. They're how people recognize you, right? Your goal as a small business owner is for somebody to see your icon or somebody to see your name and associate it with who you are and what you do, right? And that's what we're building. And trademarks become a very important part of building your brand, and to make sure that you protect them, and to know what to do when somebody actually violates your rights and how to approach it, right? And to understand what starts to matter. So my goal today is to make sure that you understand trademarks and how they impact your business, how to protect them, and how to enforce the trademark rights that you have. And I consider that to be a win. I'm going to stay to answer any questions you have. I do want to tell you, and we've got some cards over here. We've got a giveaway, 5 ways to protect your trademark. It's a downloadable PDF. If you will send an email to info@gatehouse.law, it's on these cards over here. Then we will send you back. The PDF download so that you have it, and then you guys will have our contact information so you can ask any other questions that you may have. Do I? We're all small businesses, right? So my goal at this point, though, is to stay and answer any questions that you do have. I do want to make sure that you guys understand that I know lawyers are expensive, and startups often don't have all that much money, right? And we've taken a completely different approach to the way that law firms should relate to the small business community. That's how we're redefining business law and lowering the barrier of entry. And so we have flat fee, products that work for small businesses, and it's always up front. We always tell you what it's going to cost and how those things are, what it's like to work with us. But outside of that, our goal is to actually help you understand the legal that impacts your business. So I'm here to answer your questions until Kim kicks me out.
Well, I'm just gonna say, because I do want to be respectful of everybody's time, so I'm gonna like stop this. Oh, and looks like it stopped. Did it? Oh.